Hello, my name is Tom Hartmann with the Hartmann Law Firm. We focus on commercial litigation, and sometimes when people start litigation, of course, they want to be focused and driven and attentive and aggressive, and that's the right way to approach litigation. But you can't forget that the other side will have a view too. The defendant, the party you're suing, will not sit idly by and just take whatever you send. So you must be prepared for that. Just as in pool, you shouldn't only focus where the numbered ball goes, but where the cue ball goes. So in litigation, you should focus not only on what you're going to do, but how you're going to respond to what the other side might do. The other side might, first of all, not only answer the complaint or the lawsuit that you bring, but file a counterclaim. And that is, sue you for the same thing or something related to what you've done or what you've claimed. And under the entire controversy doctrine, they've got to bring in everything that they've got in a lawsuit against you at the time of your claim and their counterclaim. So their counterclaim could theoretically consume the entire litigation. It's at least something to think about and be aware of. And if you have multiple defendants, so you're suing multiple people, the people on the other side, the multiple defendants, can sue each other and then also file cross claims against you, which makes the litigation get bigger and more complicated and more difficult and take longer. You can also file a motion to dismiss right at the outset. Instead of answering the complaint and saying, no, I didn't do what you said I do, no, I'm not going to file a counterclaim, I don't think you've got a claim, so I'm going to file a motion to dismiss. And then they could bring in a third party and say, it wasn't me, it wasn't I that did this, it was somebody else. And you should have sued them, so I'm going to sue them and bring them in, and then that party can also make counterclaims and cross-claims and motions to dismiss. The real point is that litigation is not only complicated and not only expensive, not only takes a long time, but it's procedurally bound. So you are bound by the rules of court, the rules of procedure, whether in the state of New Jersey, whether in federal court or whatever state you try a case in. You're bound by those procedural rules, so it can take a long time and involve a great deal of expense in terms of procedure before you even get to the substance of your dispute. So you should think about that with your attorney, and I'm in the Hartmann Law Firm in Watchung, New Jersey. You should think about with your attorney, consult with your attorney, and discuss not only what your claims are, but how the other side might respond, what they might say, and how they might approach it. And this might inform whether you begin with litigation, whether you try to negotiate a settlement early, whether you try to negotiate a settlement even before you begin litigation. Because all these processes are focused on only one purpose, and that's to resolve your dispute, resolve your problem, and get you the best possible result. This is Tom Hartmann with the Hartmann Law Firm in Watchung, New Jersey. We would be glad to help you, consult with you, or assist you in any way. Thank you.